All right, so good day, everyone. I'm Harry, your moderator for this webinar on the behalf of the organizer company called Conference Panel. I welcome everyone for today's webinar, which is called Advanced Directives, Ensuring Compliance with CMS and TJs. I'd like to introduce our presenter for today. She is like my all-time favorite speaker now, and her name is Laura Dixon. So now I would like to hand over the floor back to our speaker. Over to you, Ms. Dixon.
Great. Thank you very much, Harry. And welcome everyone to today's program. As Harry mentioned, we're going to be talking about advanced directives. What about case law? And we're going to come back to that case. Don't worry about that. As far as case law, there are multiple cases related to advanced directives. For example, look at this patient here on this slide. This is slide number 13. He has a whole host of items going on with him. He is intubated. He is in a sedation-induced coma. His eyes are concealed or they're taped. He's on multiple IV medications. This man is not in good shape, let's face it. Now, if he were of a certain age or maybe a certain medical condition, do you believe he would have had some information or something that he would not want done to him if he had the decision capability to be made? Overall, a mentally competent individual, an adult usually, has the legal right to refuse treatment. They don't have to take the care. They don't have to. If they're competent and they're of a certain age according to your state law, they can say, no, I do not want that done. And okay, we may not agree with it. We may not like it, but we have to respect it. We have to abide by it. Joint Commission, CMS, they require hospitals to honor those rights to refuse treatment. And by the way, this must be an educated or informed right. They have to know what are the risks, what are the benefits, what are the complications, the outcomes. Well, the outcome, of course, will probably be death. But they have to know what are those risks if they don't accept our treatment. Two major cases, Quinlan and Cruzan, they helped establish the right to refuse life-sustaining treatment. And this broadened that law to include non-competent patients. Now, the earlier cases before Quinlan and before Cruzan, there had to be a court-appointed guardian that would step into the shoes of the patient and make those decisions. With Quinlan, this was the first case to ever mention the condition known as a permanent vegetative state. Ms. Quinlan took an overdose and arrested at age 21. And so for the next multiple years, she was removed from the ventilator. And they thought at that time, okay, this is it. Well, she didn't die. Karen started to breathe. And in fact, it was not until 1985, 9 years later, after she had been taken off the ventilator, that Ms. Quinlan did die. And she died as a result of pneumonia. I've included the case reference in this particular one. But again, even after being off the ventilator for 9 years, she was in this persistent vegetative state until the pneumonia took her life. Nancy Beth Cruzan was a little different. She was still a very young woman, 25 years old. She was in a rollover accident. She was found 35 feet from her vehicle in a ditch and not breathing by the time EMS arrived. They believe she had been without oxygen for at least 15 minutes. Maybe longer. They couldn't fully establish it. Over the time, Mary Beth was in the hospital. She had, of course, she was on a ventilator. She had the feeding tube inserted. She was able to come off the ventilator. But the question is, that feeding tube, that's life-sustaining treatment. Now, the family had requested the tube be removed after 5 years. But this case didn't end at 5 years. Theresa Schiavo, another case, another young lady. She had a potassium imbalance. She was quite the dieter and was a long-term runner, etc. Age 27, she arrested because of the potassium imbalance. She was in a persistent vegetative state since 1990. 6 years later, her then husband petitioned to have that feeding tube removed. Again, this is life-sustaining treatment. Her parents fought it and fought it, saying, no, that's our daughter. We want her to live. Over another 9 years. So now we're up to 15 years since this occurred. The court finally said, you know what, husband, you are right. Based on all the information that came out, all the testimony, all the comments, the court agreed with the husband and said, you know what, okay, maybe it is time. So it wasn't until 2005 that that feeding tube was finally removed. Upon her death, they did, of course, do the post, and this is what they found. The CT on the left, the brain, that's a normal brain. That's yours and my brain. On the right was Theresa's in 2002. And you can see there's been a massive loss of brain tissue. That black area, nothing but hydrocephalus. Her brain was half the weight of a normal brain. We're not done yet. Know who is and who is not a do not resuscitate. This comes up multiple times in extended care facilities, long-term care facilities, your nursing homes, in particular Glenwood Gardens. It's in Central California, independent nursing and living facility. They refused to do CPR on an 87-year-old. The nurse, according to what her testimony was, because yes, there was a lawsuit, of course, the policy of the facility said, I can't do CPR. So this resident collapsed in the dining room, and instead of starting CPR, they called 911 and waited. There was no DNR order on this patient. Now the family was okay with the process, but what happened as a result of this, CMS came back and said, look, okay, unless there is a DNR order, an advance directive, something giving you direction on what you do and do not do for a patient, you must do CPR. That is just basic health care. That is what we have dedicated our education, our training to do, is to take care of patients unless they say no. And that's a refusal, and that accounts for what an advance directive is. So again, this patient did not have a DNR. She did not have an advance directive. It was a facility policy that established it. And CMS said, no, that's not right. That's wrong. There are other cases that bring home this issue. Linda Scheible. She was in a Florida nursing home. She had an advance directive, and they didn't honor it. Cost them $150,000. And this was one where this patient had completed a living will that specifically said, don't do CPR. Do not do life-prolonging care, sustaining care. I don't want a feeding tube. I do not want surgery. I do not want a ventilator. And the doctor even wrote, do not resuscitate into her record. So that should have been a red flag. Well, there's another case. Pregnant patient. She was declared brain dead. And this is the one where the husband gets this massive bill for her care. They were the parents, this patient, there was another one, excuse me, where the patient and the mother were awarded $16 million because they didn't honor it. The patient here had a seizure disorder. Physician said it's just going to get worse. It's not going to get better. We cannot control it. There's nothing we can do. So the advance directive gave mom the durable power of attorney so that if I, the patient, became incapacitated, mom can step in my shoes. That's what it's there for. Okay. What happened is the patient did go into cardiac arrest. She was intubated against her wish. She was in a coma for 2 months until now they have determined she's in a persistent vegetative state. She's total care, completely disabled. This was the first of its kind where substantial damages of this nature were awarded. Now, with the pregnant patient, that's the one where the patient didn't end up paying the bill. They took care of the bill. The other, it was $150,000 because they did not respect the patient's wishes. And with that, I want to say thank you for everything all of you do. Thank you for everything you do for your patients, and stay well. Thank you very much.
Thank you, ma'am.